In this video, I am going to dispel some of the more common California divorce myths. Okay, myth number 1. Your divorce has to happen in the state in which you were married. This is false. Your divorce can happen in the state in which you are currently a resident of, because that gives the court jurisdiction to hear your case. Divorce myth number 2. I'm entitled to my marital standard of living. This is probably the most common one that I come across in mediation. And if you think about this logically, you have one house, and whether you have 1 or 2 incomes, there is a set amount of money that you have lived off of as a marital community. And now we are going to split that in half and start 2 new lives and have 2 new households. So it would be virtually impossible for you to maintain the exact same marital standard of living that you had living under one roof, under 2 roofs. So what this actually means when people say this is that once your divorce is completed, we want to make sure that we have equalized both parties so that we don't have one person living in this beautiful mansion and the other person living in a 1-bedroom apartment. It's to create equality in your standard of living for moving forward. But it's a misnomer to think that you are going to be able to have the exact same standard of living that you enjoyed as a marital community when you are separate and you have 2 new communities. Myth number 3. Divorces are finalized 6 months after they are filed. That is not true. That is false. When you file your petition, that does not start the 6-month clock that everyone's heard about under the California Family Code. It's when the respondent is served, because that's when the other party is being put on notice. So that's when the 6-month clock starts. Now, carrying that thought a little bit further, the only way your divorce is going to become finalized at the end of that 6 months is if you've completed the entire process within that time period. If you haven't, which is actually very common in litigation, then that means your 6 months is going to run, and then it's just going to keep running until you complete your case and until that final day when the judge enters the stamp on your judgment, and then that will become your official date of divorce. Myth number 4. Wedding rings and engagement rings are divided as part of the marital assets in a divorce. This is false. Wedding rings and engagement rings are actually considered gifts to the community or gifts to the person who received them. And any gifts or inheritances received during the life of a marriage are considered separate property. So they are not typically a part of the division of community assets in a divorce proceeding. They stay with the person who they were gifted to. Myth number 5, the courts favor mothers in custody battles. The courts actually don't favor mothers or fathers in custody battles. What they are looking at is what's in the child or children's best interest, and that is at the forefront of all of the decision making as you go through your divorce process or custody battle. So there isn't any primary focus on one parent versus the other. Myth number 6. If you have 50-50 custody or joint physical custody, no child support is paid. This is false. Now, that doesn't mean it couldn't happen, but child support is not solely based on your percentage of custody and your visitation schedule. It's actually based on a number of other factors, but a primary factor in that being your incomes. So if you have someone's income that's at $100,000 and you have someone's income that's at $40,000, and then you're going to have 50-50 custody, we have to equalize the disparity in the incomes so that we can create continuity and consistency in the home environments for the children from a financial perspective. And child support covers food, shelter, and clothing for those children. Myth number 7. Spousal support or alimony is ordered for half the life of the marriage. So in some cases, this could be true. The kind of standard rule of thumb is if you are not considered a long-term marriage in the state of California, which means that you've been married for less than 10 years, the rule of thumb is that you could potentially be eligible to receive spousal support for half the life of the marriage. But that does not mean that there aren't going to be mitigating circumstances that a court can take a look at. In addition to that, if you are considered to be a long-term marriage, which means you've been married for 10 years or longer, then you can potentially have spousal support ordered for a much longer period of time, and in some instances, until that spouse would die or remarry, so that it would go on indefinitely. And again, the court has jurisdiction to look at mitigating circumstances surrounding that spouse's ability to earn their own income, their educational level, how long they've been out of the workplace, if they have any disability of any sort that would prevent them from either working part-time or full-time, and a few other circumstances such as those. And last but not least, myth number 8. I can discharge my spousal support and/or my child support if I file bankruptcy. This is false. You cannot discharge either of these debt obligations if you file bankruptcy. If you'd like more information about these California divorce myths or any other things that you've heard and you're wondering if they're true or not, feel free to visit our website at www.mmediations.com.